politicians won't.
Well, that's true.
There we are. Dirk?
Yeah, I would just add that courts provide the feedback loop for regulators to know whether they're right or wrong. To your point on unintended consequences, or basically how the bill will play out, I think it really depends on how you view the current situation. Do you, again, I think it's what I started with, do we think that big tech firms are big and successful because their products are extremely good, or is it because of anti-competitive behavior? Depending on one of those, which of those two things it is, I think the effect of the bill will be very different. I would offer a couple of illustrations that are along the lines of the ones you suggested. So you look at the history of competition law in digital markets, and it seems that there's this repeating pattern of regulators sort of end rivals, getting what they want, winning the cases, but that not making a difference. And I think, I'll go through 3 cases and I'll explain why I think it's basically because of what I just said, because I think in those cases the platforms had the better product. So you can look at the 2 Microsoft cases brought by the EU, basically about Microsoft refusing interoperability information to rival browsers, tying the Windows Media Player to Microsoft Windows, and tying the Internet Explorer browser to Microsoft Windows. There were two remedies in those cases, 2 important remedies, 3 remedies in fact. Each of them failed. The one was the one you mentioned, the Windows XPN, so telling Microsoft, you are now going to sell a copy of Windows without the Windows Media Player baked in. Consumers didn't go for that. As you mentioned, they sold about 1,000. I can't remember the exact number, but it was extremely small. Second one, they said, the European Commission said to Microsoft, you must provide interoperability information to rival server software developers. That case was litigated. Microsoft and the developers could never agree on at what price that interoperability information would be provided. Because, of course, Microsoft had invested in its product, and there was no reason for Microsoft to give it away for free. So again, the remedy appears to have been a bust. You get years and years of legislation, and by the time the case is finished, the market has moved on. Basically, the rivals wanted it for free, and that was not going to happen. Third Microsoft case on the tying the Internet Explorer browser to Microsoft Windows. The Commission says, okay, Microsoft, you will offer a choice screen so that me, when I'm a consumer and I boot Windows for the first time, I choose between browser options. At some point, we're led to believe Microsoft will say it's by mistake. The Commission says it's absolutely not by mistake, but the browser choice screen disappears. How long did it take for anyone to notice that the browser choice screen disappeared? Months. No one was concerned. It's just, at the end of the day, consumers went on with their lives. They were not using the browser choice screen as the regulator might have expected. And finally, last one, the European Commission brings Google proceedings against Google for the Google shopping box and says, look, from now on, you can't, when you search for, say, shoes on Google search, the first result is this shopping box that enables you to directly purchase a good. Rivals say, we want to be displayed there too. The Commission says, I'm simplifying, but yes, Google, you must display rivals. What happens? Google says, okay, fine, we'll display rivals, but we will charge them a fee to be there because this is our most valuable real estate. All of a sudden, rivals say, well, we won the case, but essentially we lost because we can never outbid Google to be at the top of the shopping box. And I think you'll have these problems here.